Going to our recordings in progress. As we, I'm going to go over some logistics about how we're going to do some of the voting and things like that later, but I'll go ahead and start with the Pledge of Allegiance and call Jamie McDowell.
Good morning, everyone. Please stand and place your right hand over your chest and join along with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
And now I'd like to call Josh Boson to lead us in the invocation.
Good morning, greetings, and Shabbat Shalom to each of you. My name is Joshua Boson, and I have the great pleasure of serving as a member at large on the Board of Governors this year. In Judaism, my faith tradition, today is the Sabbath, a sacred time to rest, set aside the work of the week, and honor the Lord our God. For some Jews, Shabbat means restricting oneself from certain kinds of physical tasks or commercial activities, and instead engaging in significant prayer, ritual, and religious learning. And for other Jews, Shabbat provides a more simple opportunity for spiritual reflection on the week just ended, a time to visit upon challenges, celebrate successes, and ponder the infinite wisdom of that yet unknown. This Sabbath, we are fortunate to gather here as a collective, some in person and others via Zoom, to take up important decisions, do good, and share with each other the hefty burdens of our chosen profession. What unites us in that purpose? Justice. Tzedek, tzedek, tirdof. The Hebrew translated to English commands as follows: justice, justice thou shalt pursue, that you may live and inherit the land which Adonai your God gives you. This declaration, taken from the book of Deuteronomy, is one of the most central declarations of the Torah, the first 5 books of the Hebrew Bible, and in a more general sense, Judaism's written law and the foundation of the Jewish faith. But why 2 tzedeks? Justice times 2? Such has been the subject of great rabbinic debate over the centuries. One commentary resonates especially with me. Rabbi Eliezer Maya Bloch, a leading Orthodox Jewish rabbi in the United States in the years after World War II, opined thusly: the pursuit of justice must also be pursued with justice. We are not merely being taught to run after justice, we are commanded to run after justice with justice. And so as we begin the opportunity of the day, that ever valiant effort, let us pray together. Sovereign of the universe, who has sustained us and enabled us to reach this day, bless us that we may be a blessing to each other, both in word and in deed. Guide us in our benevolent and fruitful undertakings to create a better world for our colleagues, families, friends, and those persons whom we have chosen to represent and care for in service of the law and its good and profound work. Help us to honor the lawyer's creed and enable us to demonstrate and offer to others that fairness, integrity, and civility that our noble profession demands of us. Honorable Lord, bless the members of this Board of Governors and guide their deliberations today, that they may undertake their great tasks with compassion, grace, love, wisdom, and justice. Tzedek, tzedek, tirdof. And may all of us bring honor to your universe, your people, and all humankind. Amen.
At this time, I'd like to recognize our special guests. If I can find a piece of paper. Aha. All right. From the Supreme Court, we have Chief Justice David Namias, who's participating virtually, Justice Nels Peterson, who's participating virtually, and Justice Charlie Bethel, also participating virtually, Justice John Ellington, and we also have Justice Sean Ellen Lagrua and Justice Verda M. Colvin in the room. From the Court of Appeals, we have Judge Elizabeth Gobeil. She's here today in person, and Judge Ken Hodges will be participating virtually. We also have some past presidents, including Bill Barwick, Ken Hodges, again, Judge Ken Hodges, who's participating virtually, Linda Klein, who's participating virtually, and Pat O'Connor participating virtually. And then we also have David Dove from the governor's office who's joined us. I will say it's a little light in the room. We have, we're about 50-50 virtual participation versus in person. So just so you can kind of get a handle on what the landscape's going to look like. We've got a pretty robust group that's participating virtually. All right, with this, we're going to call Ivy Cadle, our secretary, forward, and he's going to do the roll call.
Thank you, Madam President. It's come to my attention that I believe one of our sheets got missing from our annual meeting this summer. And so if you will examine the board book and make sure that it properly reflects the status of your attendance. If it does not do so, if you will let me know. And so you need to check both days of the annual meeting to make sure that the board book is correct. And it's also kind of come to my attention that the only real check and balance is to make sure that it's accurate is for you to check it and let me know. So check the book, make sure your attendance was adequately reflected. And if not, please send me an email. To that end, we have the sign-in sheets. So make sure that you sign in. There are 5 of them. And if you find that it's reached the end of its usefulness, if you could collect those maybe at the corners of the room, just kind of send them off to a corner, that will help us make sure that we have all of them and that we have fewer people who are recorded inaccurately. So thank you. I'll pass these out. If you'll pass them around to your friends, that would be most helpful.
Thanks, Ivy. And along those lines, if you're participating virtually, of course, your attendance is going to be recorded through the Zoom platform. And along those lines, let's just remind everyone, please be patient today as we navigate another hybrid meeting. We're getting a little bit better at these, but it's still, there are a lot of moving parts. And as a reminder, if you're attending virtually, please make sure your name is displayed correctly in order to be counted, present, and recognized for discussion. The chat will be enabled for the participants in Zoom, but will not be monitored for questions. And Q&A is enabled and will be monitored. So you can use the Q&A feature to ask questions if you'd like. And to be seen and heard for the questions or comments, you need to use the raise your hand feature, and you will be recognized and promoted so that you can be seen and heard on the screens here in the room. And as a reminder today too, only board members are allowed to vote. So if you're in the room, that means you have a green name tag. We are going to be using the Turning Point software as the voting platform. So I've gotten emails about it as recently as this morning. If you're using a clicker, please do not then log on and use the app as well. Let's just have one vote. And if you have any questions or you need any help during the process, Mike Monahan is going to be here and can help. And then if you are virtual and need any help with that, you can email Guy Key at the bar. So with that, I think we're going to move on to the future meeting schedule. Just want you to highlight that, and you can check that out in the board book at pages 11 and 12. And just wanted to make a note, it says for the spring meeting that it's a pending contract. We're set with the hotel. It's just the Classic Center. We're finalizing some things with them, but the meeting is going forward, and I hope everyone can make plans to attend as we go forward. I think now we have a test question that we're going to practice with to make sure that we're good before we're about to roll into the action item of the meeting, action items of the meeting. And so we've just got a little test question to make sure we all know what we're doing and how we're doing it. And there's your practice question. So And in the beginning, as we're kind of getting started, we're going to leave the polls open a little bit longer just to make sure that people are good and can figure out what to do. And we'll make sure and tell folks before we close down the voting. It's a really serious topic and discussion. A resident-elect would like to be heard on this topic. Good. Okay. We're waiting to see if everyone could vote. I know it's not, this is a way for us to gauge truly how many people we've got here. Okay. While we're still waiting on those votes to come in and I'm going to say calibrate the system, so to speak. Just a reminder, your session ID is fall 21 BOG. And make sure your name is entered in your email, because that is also how we're verifying that Board of Governors members only are voting. Okay, all right. Well, we're going to officially close this poll question. There you go. Blue wins. But that's a good preview just for everyone to see what it looks like. So that way you can see how many voted. That's fun. Good for us. All right. Okay, now moving on, we're actually gonna have a real vote. Next on the agenda, we've got the minutes of the 287th and 88th meeting of the Board of Governors. Mr. Cagle.
Try this. I'm gonna try this podium out too, that was loud. In your board book on pages 13 through 25, you will find the minutes of the 287th and 288th meeting of the Board of Governors that occurred on June 11th and June 12th of 2021. Does anybody have any corrections to the minutes? Do I have a motion to approve? A second? Now I'm going to let Madam President run the voting machine.
Well, there you've got it. You've got a motion and second, and now you can. Any discussion? Would anyone like to discuss the minutes further? All right. We're just going to leave this poll open again just for about 30 seconds so that we get our feet under us. And for the folks at home, we actually have a way we can see how many votes are coming in. So we're just trying to make sure we get to the right number of everyone voting. Okay. All right. And we're going to close the poll. I definitely know that's probably Jack Long and someone else voted against the minutes. I know you did. I know it. All right, next up, we've got proposed rule changes. If Bill Neesmith, if you could come to the podium.
If you will look in your board book on page 26, this is not really a proposed rule change. What this is that the last time that we did or brought in the 2019 fall meeting, y'all approved several amendments to the rules. And it was a very large amount of changes. And one of the changes was a comment to Rule 1.1 competence, which is comment 6, And you can see the change that was made there. And then when we submitted this to the court for approval, the court was a bit concerned because of the large amount of material that was given to the board, and this being the only thing that deals with electronics, that they wanted to make sure that this is something that the board really intended to do. So if you don't want this to happen, then you have to make a motion to rescind it. It takes 2/3 majority of the people here present and voting to be able to overturn it. If not, we just do nothing. So
truly, we are here today to determine whether or not we want to rescind this comment to this particular rule. Yeah, and if so, is there a motion to do so? Or would anyone like to ask any questions? Oh, and then, well, need to know about Zoom. Excellent.
thank you.
Yeah, we're on the next. All right, thank you, Bill. What's your next item?
All right, the next thing is the fee arbitration rules. This is on page 30. Get Mr. Wonderful up there. What this is that for years we've had a fee arbitration system that was different really from like regular arbitration. The court wanted us to make it where, I mean, before a lawyer could agree to arbitrate but not agree to be bound. So what this does is make the arbitration rules follow pretty much so the arbitration code of Georgia. This was a request by the court and by the executive committee. There's been a lot of work on this, and I've got a memorandum of all the changes. I don't want to read them to you, but I'll be glad to answer any questions. David had a lot to do with the drafting of these rules, and he may understand them even better than I do.
Well, and on page 30 is an executive summary that pretty well sets out the changes. So we can answer any questions. But essentially, this is what the court wanted, so here we are.
So at this point, we're looking for a motion to approve. I got a motion and a second. Yeah. Thank you, Mr. Wilson. Any discussion, any questions? We've got a motion to approve the VR rules as presented. Any debate? Anybody on Zoom? All right. Yeah. Oh, the next one? No. Nope. There we go. There we go. We'll leave it open for about 30 seconds or so. Okay. Jackie's going to come help you out right now. Everyone just take a break while we sort this one out. How many? Oh. All right, we're going to close the poll. And there you go. Motion passes. All right, next up, a little small issue we like to call professional liability insurance. I'm going to recognize Chris Twyman to come to the front and take the assault.
I know it ain't the stallion. You know it's your girl. I know it ain't the stallion.
video that was.
I know it ain't the stallion.
With this
You know it's your
very issue of
girl.
professional liability insurance. We know that there's
I know it ain't the stallion. You know it's your
sometimes there's life
girl.
experiences that you grapple
I know it
with.
ain't the stallion. You know it's your girl.
All that important. And that was kind of
I know it ain't the stallion. You know it's your girl.
I'm at a Braves game a couple of weeks ago.
I know it ain't the
Mom coming in for the
stallion.
save and,
You know it's your
and for the
girl.
block. And one of the things that, you were at that
I know it
game.
ain't the
saw that play out.
stallion.
You now have a small peek into how things operate in my house. And the same way my wife went in for the block there in front of 60,000 of our closest friends. That's exactly what she does when people come up to me to talk to me about professional liability insurance. And it's been shared so many times on the platform that I really feel like I'm entitled to some royalties, and I may need some legal help. Is there a lawyer in the house? As we get ready to debate this topic, I do want to start by thanking a few people, and I haven't seen Daryl Sutton this weekend, and I think there's a reason for that, because I really want to thank Daryl. I really want to thank him for appointing me to chair this, but seriously, it's been a privilege. It's been a lot of hard work by the committee, and you're going to see the names up as we start our slide presentation. In fact, let's go ahead and move to the next slide, and you'll see the names of all of the people who put hard work into this issue. And when you see them, please thank them, regardless of where you fall on the issue. A lot of hard work went into this, and I really appreciate their service and leadership. Also, thank you to Paula and her staff for all the work that they did to help us get to this point. So if you'll turn the page, you have your board book, you can turn to page 107, and it outlines all of the options that were put together by this committee, and we'll start with those options as we continue through the slide presentation. And as we go through, and if you'll go ahead and put up options, I guess it's going to be 3 clicks. Option 1A, we've added 1B, and an option 2. And as I start to go through these, and I know you've read about this and you've heard it, certainly want to be clear about some of the terms. When we say disclosure in all of these options, what we're speaking of is disclosure to the bar. And that disclosure would occur on your annual dues statement. You would simply inform the bar, you would disclose to the bar whether or not you currently carry professional liability insurance. When you see the word publication, publication simply means that your status of whether you carry insurance or not will be on your bar directory site. Okay, it's not going to be in the AJC, the red and black, or any other publication you might read. It would be on the bar website. And so with option 1A, mandatory disclosure with publication means that a member of the bar would simply tell the bar on the dues app whether you carry insurance, and that information would read on the bar directory as this member does have professional liability insurance, does not have professional liability insurance, or is exempt. Option 1B was added so that it would allow, if this option were chosen, members to inform the bar of whether the member has professional liability insurance, but there would be no publication on the directory. And so simply put, 1B simply informs the bar as to whether or not the member has professional liability insurance and allows the bar to collect that information. Option 2, disclosure on the dues statement. And if the member does not have professional liability insurance, the bar would encourage and recommend that the member complete a risk assessment. And I'll talk more about that in a minute. But the risk assessment course would be completely voluntary. Our next slide, option 3. Option 3 has an A and a B. Option 3A would be disclosure without publication on the member directory, but the CLE, the risk assessment CLE would be mandatory for those without the professional liability insurance. And then option 3B, disclosure with publication and mandatory CLE for lawyers who do not have professional liability insurance. That brings us to option 4. Option 4 is the all-in. Option 4 is a rule that would require members to carry professional liability insurance to be a member of this in good standing with the state bar. And so those were the options that were put together by the committee after, gosh, what, 2.5 years of work and much debate and many meetings. And as we came out of the summer meeting, we met so that we could, for one final time, deliberate and vote as to what we would recommend in this meeting for action. And this next slide shows you here how those votes of the committee fell. And I know that it may be hard to read, and so I'll go over those. For option 1A, which was the mandatory disclosure with publication, it did not yield any votes of the committee. Option B, mandatory disclosure to the bar without any publication, 1 vote. Option 2, mandatory disclosure with a voluntary risk assessment, 5 votes. And I'll tell you that it was a plurality vote, as you can see, but that option 2 received the most votes in the committee vote. Option 3A, mandatory disclosure without publication, but with a mandatory risk assessment, 2 votes. And then 3B, which was disclosure with publication and a mandatory CLE, 1 vote. Option 4, requiring professional liability insurance, 4 votes. Now, option 5 was not a published option, but we gave the committee members the opportunity, if they wanted to express, to take no action. And so that's where you see on our slide there, option 5, which was a no action vote. 2 members of the committee voted for no action. With option 2 receiving most votes in a plurality out of the committee, I'd like to go over that one in a little bit more detail. And so here is option 2. Lawyers in the private practice would have to disclose to the bar whether they're covered with insurance. And this would be published. It is a published option in the bar directory. The information will be due on your dues statement. And if you fail to disclose this by September 1st, you would go out of good standing. And you have to disclose this. If you're out of good standing, you have to disclose to membership your PLI status to go back into a good standing with the state bar. Mandatory disclosure with a voluntary risk assessment simply means that we're encouraging those with coverage to, we're encouraging those. We can go to the next slide. So we would encourage all lawyers who do not have professional liability insurance coverage to take the voluntary risk assessment. It is voluntary. So under this option 2, we're not making you do anything. Just tell the bar if you have insurance. At that point, the risk assessment is completely voluntary. But here are some of the benefits to completing the risk assessment. It is a free CLE. Free. And you get credit upon completion, and the results of your assessment would remain confidential. And you know, the purpose of the risk assessment is obviously it's like a tune-up, right? You want to be in a position to know that you're doing the right things in your practice to avoid and steer clear of a malpractice claim. The next slide deals with the exemptions under this rule. And by the way, this particular rule that I'm going over, if you have your bar book, I believe it's on page 112. And so the exemptions would include those members who are in an inactive status, who work for the government, are in-house counsel, or serve as a mediator or an arbitrator. And there are many other exemptions, just so you'll know, that were discussed and debated, but we believe that these are the necessary exemptions to keep the rule effective. And we know we heard from several people about what these exemptions mean, but we do believe that this is a sufficient number of exemptions and would cover those who we would not expect to have professional liability insurance. If you continue through these slides, and we'll move through these, two different risk assessments that we looked at that we would model the Georgia risk assessment after include the Colorado model. You can see there that Colorado focuses on 10 self-assessments, from developing competent practices to avoiding conflicts of interest and how to properly maintain and secure and retain files, confidentiality issues, law firm and law practice management, including finally wellness and inclusivity. Okay, 10 assessments for the Colorado model. As we continue, the Illinois model has 8 different assessment pathways, if you will, and we would gladly provide this information. It's been provided to you, I'm sure, in electronic format, and you can go in and you could actually go take one of these sample assessments if you would like. But these are some of the assessments we looked at when developing the rule. And if we move past the Illinois model, we get to mandatory assessment costs. In the first year, it would cost our bar $25,000, less than $1 a member, to put this program together, to roll it out. And then for each year thereafter, we're talking approximate cost of $10,000. Only a quarter out of your pocket. Now, the rule itself, and this is what's on page, I believe it's 112 of your book, Rule 1-210, disclosure of professional liability insurance. Option 2 is laid out there. And again, it just highlights this rule. I've already highlighted in earlier on what it would do. You would disclose to the state bar whether you have professional liability insurance. Part B provides for the exemptions, including those who are inactive, employed by the government, arbitrators or mediators, or in-house counsel. And then it talks about if you cease to carry professional liability insurance within 30 days of a change in your PLI status, you would need to report that to the state bar. And then how it would be listed on the publication as covered, not covered, or exempt. And importantly, it says each member shall provide to the state bar of Georgia confirmation of coverage upon request. We're not requiring that to be sent in under this rule affirmatively unless there is a request coming from the state bar. Again, the assessment, we would strongly encourage those to take it if you're not covered. And then part F of the rule is the language on good standing. So it's been a privilege, really, to work with everyone to come to this day where we have the opportunity to consider professional liability insurance and what, if anything, the bar will require on professional liability insurance. I certainly wish everyone were here so that we could have everyone in person for what I know is probably to be a robust debate. But with that, and on behalf of the committee, after the committee's recommendation with 5 votes being that we adopt option 2, Madam President, I would make a motion that we adopt option 2 as presented and make that rule 1-210 on professional liability insurance.
Madam President, before we take that vote, I think that it's incumbent upon us.
Okay, I've got a second. Now I'm going to open up the floor for debate, but I've got people who were queued up already, who submitted our forms that we have. So we're going to go through the people who submitted the forms like we asked because we were trying to gauge time. And then I'm going to open it up folks in the room and then on Zoom. Okay, so I'm going to start first though with Martin Valbuena. Do you still have an interest to speak? Okay.
I want to thank the committee for the long work. What I've done over these 2 years is as I report to my constituents, I keep bringing it up and asking them for input and asking them what they wanted to do. They kept asking me to do a survey. I kept trying to figure out a way to do a survey. And then I kept sort of saying, well, maybe the bar is going to do one or the committee's going to do one. Because what kept coming up to me was two issues and problems that they had with this from different lawyers. And both from lawyers that would be covered by the rule as it's proposed and would not be covered because in the Paulding circuit, we have primarily solo practitioners and people that would be covered under one of the exemptions. And a lot of times the discussion kind of flowed around, but I've kind of synthesized it to sort of be that they kind of came up with there's 3 groups of lawyers. Group number 1, obviously there's more than 3 groups of lawyers, but for purposes of this discussion, group number 1 is the lawyers that have malpractice insurance already. And some of those lawyers are good lawyers and some of those lawyers are bad lawyers, to oversimplify things. And if they end up, the good lawyers with insurance pay their dues and hardly ever have a claim or never have a valid claim against them, just like the driver of a car that doesn't get in a wreck. The bad lawyers are happy they have the malpractice insurance because they do have claims against them and they have the security of knowing they've got the malpractice insurance to cover them. The second group is the good lawyers that don't carry malpractice insurance. They've at some point made a decision that they're not going to carry malpractice insurance. They're going to take that risk. And they think that because they're a good lawyer, it's not going to come back and bite them on the butt. And because they're a good lawyer, for the most part, they're right. They never have malpractice claims and they don't have malpractice insurance. And then the third group is the bad lawyers who don't have insurance. And those are the ones that you have a claim against. They have a client who has been wronged. There's a claim there, but there's, for the most part, probably not any way for the client to get compensation because the lawyer, being a bad lawyer, probably doesn't have the assets to handle the claim, most likely. What my constituents kept asking me and what kept coming up, and again, is how many people are in group 1? How many people are in group 2? How many people are in group 3? Is group 3 really a problem? And I would circle back to the discussion that we've had at different presentations where, you know, the committee has made presentations and they say, well, there's these people out here, yes, and everything. And basically in my circuit, the answer was no, there's not really a problem, or they haven't been shown that there's a problem. And so they don't want me to vote for any disclosure and they don't want me to vote for any mandatory insurance. And the reason for that is because until you show them there's a real problem, then they're not willing to change the way things are. That leads me into the kind of the second point they kept making, which is out where we live, there's car wrecks and there are people that do plaintiff's personal injury. And their practice has been overtaken and hardly any of them make the primary source of their income anymore from doing plaintiff's personal injury. And the reason for that is because of TV ads. The TV ads and the billboards from the large personal injury firms swallow up, marketing wise, the majority of the cases. And I think I had people say to me, you know, that's what's going to happen. If you have mandatory insurance or you make us disclose that we have it, we become targets. And then there's going to be all these billboards and there's going to be TV ads talking about, did your lawyer mess up? Have you been injured by a lawyer? And then there's going to be this new cottage industry that's going to take off because now there's insurance for the people to go after. I had a friend tell me that he was in Jamaica just a couple of months ago. He got off the plane in Jamaica and there's a huge billboard for a lawyer that does a lot of billboards that says, were you injured in Florida? Call this number. And he said, that's what's going to happen if we make mandatory insurance or make it disclosure, because then you become the person with the target on the back. I do think this impacts small firms and solos the most, which is generally what we have in Paulding. And that's why they're bringing it to my attention and asking me not to vote for any of the options and to just take no action. At the end of the day, the biggest issue for me is still the same thing, that I'm not convinced that this solves a problem that exists. Thank you.
Thanks, Martin. Okay, so what we're going to do, just to one, Chris, you can, if you want to sit. I mean, I don't want you to
No,
stay here for the
I'll
rest of
sit.
your
I'm
life.
happy to take questions or have committee members help me if this needs.
All day. So what we're gonna do next, the next person on the list is Seth Kirschenbaum. He is participating virtually. So Seth, if you could raise your hand and then we can promote you on Zoom if you are still interested in speaking. And after Seth, I have Martin Cohen as next, who's also participating virtually. And also when we get back to the folks in the room, if you could say your name when you come to the mic, or if you would come to the podium and say your name, that way the folks at home can see you, and then we're just clear. We've got to remember too, we've got these people virtually. All right, I think Seth is next. Okay.
Good morning. Can you hear me?
Yes, Seth, we can hear you. Good morning.
Okay, thanks. Well, first I want to thank Chris and the committee because I know you guys did a lot of work for years to get to this point. And I don't want you to think that in my remarks that I or other folks that think like I do discount the value of your service. I am in addition to being a member of the Board of Governors, I'm also a member of GACTL, the Georgia Association of Criminal Defense Lawyers. And GACTL has taken a position opposing either mandatory PLI or mandatory disclosure of PLI status. And I believe that there was a letter from Kim Dimecki, who's the president of GACTL, that was placed on the desks of the folks who are in attendance. There was also, the letter was also supposed to have been emailed to members of the Board of Governors. And that letter does lay out in detail the position of GACTL on this issue. And echoing Martin's statement, we in GACTL and me personally don't necessarily think that this is an identified problem that needs fixing. And in our letter, the GACTL letter, we note that there's no other major profession in Georgia where it is required that the practitioners maintain professional liability insurance. Doctors are not required, accountants, architects, insurance agents, dentists, optometrists, engineers, financial advisors. None of those professions require PLI. And we don't think that lawyers should be forced into that position. We think that public disclosure has the potential to elevate the maintenance of PLI above considerations of competence and suitability, where clients will say, do you have insurance? That'll be more important than the competence of the lawyer. And we're concerned that public disclosure would incentivize lawsuits against lawyers. And there's even been some lawyers that we've talked to who have been concerned that if there was mandatory disclosure but not mandatory PLI, they might actually drop insurance to avoid nuisance lawsuits from people who found out they had insurance, so they brought nuisance lawsuits. And so we think that the only true beneficiaries of mandatory PLI or mandatory disclosure will be the insurance industry and the lawyers who sue lawyers. And the lawyers who sue lawyers have really been pushing for this proposal. And although I know that there was an effort made to move that we adopt option 2, I would ask that we consider another motion. And that is, we've got 6 or 7 with the 1A and 1B and the 3A and 3B. I mean, we have 6 or 7 8 different options here. And what I would suggest is that, and I want to make a motion, if I can do that, is that we vote for the unidentified option 5, which is to do nothing. And the reason I think it's appropriate that we vote for option 5 first, or we vote to maintain the status quo, is because that is dispositive of the issue. But on the other hand, if we vote on option 2 and that's voted down, then what do we do? Do we go to option 1A and then we vote on that, and then option 3B? I mean, that really would engender some confusion. And so I think that what is most efficient and will possibly dispose of the matter with one vote is that we vote to maintain the status quo. And so I make a motion that we vote up or down on maintaining the status quo first. And then if that passes, the issue is over. If it doesn't, then we can go to the various other options. Thank you.
Okay, so we've got a motion on the floor already about option 2. We either have to amend that motion or vote that one up or down before we can consider any other motions.
Now, the problem I have with that is that we didn't have a chance to debate before that motion was made. And I've never seen a situation where we had a conversation without that.
Yes, we are in the period where we are having the debate now. This is the debate. There is a motion on the floor and we are debating it. So that is the point that we are in right now. This is the debate. Another motion can be, so the motion that's on the floor can either be voted up or down, and you can make another motion, or you can amend the motion that's pending. But we're going to continue the debate right now. I will say this. We're going to continue to go through the folks that have comments. I know a lot of people have a lot of strong feelings. We've heard some really good, thoughtful things right now. I hope that as we continue to move forward, though, to the extent you want to just wholeheartedly endorse what someone else has said and not repeat it verbatim, I think everyone would appreciate that for the timing. So right now, I'm going to.
Point of clarification.
Yes.
I think what Seth is asking would need Chris to agree to amend his motion. So I've asked if Chris would be willing to amend his motion to consider Seth's motion.
Well, Mr. Neesmith and Chris, if you have to come forward, because it's not, you can't agree to amend it.
Well, the proposed motion is not a motion to amend, it's a motion to do something completely different. So if you wanted to ask the movement for the main motion to withdraw their motion, and then you can go through that process. Other than that, the other options are amending the one that's currently here. You can make a motion to table it till the end of the session, or you can make a motion to postpone it indefinitely or postpone it to a day certain or something like that. There are those things you can do, but you can't vote on a motion. I mean, it's not an amendment. It's a replacement. And so amendment would be like if you wanted to change a particular term too.
Madam President, I would like to make a motion. Well, first, I'd like to ask the movement to withdraw his motion, because I agree with Seth that the logical progression of this debate should be, do we do anything? And if so, then what do we do? Rather than talking about, one of these particular issues. If the movement will not withdraw his motion, I would like to move to postpone voting on that motion indefinitely so that we could entertain Seth's motion.
All right, Mr. Twyman, are you willing to withdraw your motion?
I just want to make sure everybody understands, because postpone indefinitely is something that you don't hear too often. People used to say table, and actually postpone is correct. If there's a motion to postpone indefinitely, as there is, and it's seconded and it passes, we are done with PLI. It's over. It can be brought up, but you cannot have Seth's motion after this. If it passes, no, if it passes, it goes on indefinitely, we're done. We move on to client security fund and rest.
Then I
of it.
withdraw the motion for now in order to give everybody an opportunity to speak. But I would ask the movement to consider withdrawing the motion so that we can go through this in a logical debate. And I agree with Seth that the first thing that needs to be determined is whether or not we do anything. And if so, then what do we do?
And Jack, I will consider, but right now I'd like to continue the debate. So I will not withdraw it at this time.
All right, the next person that we have that would like to make a comment is Martin Cohen. I believe he is participating virtually. So if he could raise his hand and then he could be promoted. And we need to take.
Y'all see me and hear me?
We can hear you. There you go. We can see you now too.
You can hear me?
Yes, yes. Thank you.
Thank you. My name is Martin Cowan. I've been on the board of governors for a long time. Nothing I say should be construed as directed at any individual person, period. I'm speaking in generalities. My assumption is that everyone is acting in good faith, and none of my comments should be taken otherwise. I have 5 points of conclusion, and they're going to be very short, and I expect to speak for less than 4 minutes. Point 1, concerning my interest. I have no financial interest in this question because I'm retired. Freedom is my interest. I'm interested in limited government. I am interested in slowing down the march to totalitarianism, which is rushing apace as we speak. Point 2, altruism. There is no piece of legislation that does not claim to have an altruistic motive. For every public law comes with a, quote, save the children, close quote, headline. I like to say that there is a reason for legislation and there is a rationale for the legislation. The reason is the truth. The rationale is often untrue. The save the children rationale is often untrue. Given any horror story used to justify government overreach, one could spend hours arguing the specific details. We received one such horror story yesterday, and I'm very sympathetic to the tragic case. Why couldn't we have spent the last 2 years debating that horror story? We have no time now to argue whether a shotgun with birdshot is the right tool for killing one cockroach in a room crowded with human beings. And no, I'm not asking for a continuance. Let's get this done now. Point 3, don't fall for this error. Quote, I have insurance, therefore I don't care if I'm ordered to have insurance, close quote. Freedom matters. Point 4, where does this mandatory errors and omissions idea come from? It is clear that the mandatory insurance issue is not, as they say, a grassroots issue. This idea originated with bar leadership, is being pushed bar leadership now for over 2 years. We represent 50,000 lawyers, over. Not one among them outside bar leadership came up with this idea. And why would they? Point 5, no halfway measures. Please just say no. Don't fall for any halfway measures. If you let the camel's nose in the tent, it will come in all the way. Just say no. And my conclusion is, please vote to stop this bar leadership pipe dream. Vote for option 5 when we get to it. Take no action. I thank you all for your attention.
All right, thank you. And in the room, our next one is Mike Terry. If you're still interested in coming. Yeah, if you don't mind, if you come to the podium, that way people on Zoom can see you.
Just a couple of very quick points. Number one of the attacks on the mandatory bar is that it is just protective of lawyers. that it is protecting a monopoly. And we've seen that in some of the old Supreme Court cases dealing with mandatory associations. It's time we protect the public. And the public thinks we have insurance. That's very clear. I've heard from my constituents, I have 6 in favor of mandatory insurance, and I had 3 who contacted me and said we should do nothing. And all of the 6 who contacted me and said we should have mandatory insurance were shocked to find out it wasn't already there. They had assumed. So at that point, I started calling and emailing my non-lawyer friends. And every single person thought that all lawyers had insurance. Everybody thought that. And we don't. And I will tell you, if the public thinks we have it and we don't disclose that we don't, I think it's a breach of fiduciary duty. But we can deal with that issue. But we need to protect the public instead of ourselves for once. And we do that with CLE, mandatory CLE. And the other thing I heard from the 3 people who called me opposed was, I don't want the bar telling me what to do. The bar tells you what to do in every bar rule, including mandatory CLE. It's part of being a professional, and it's part of our obligation to protect the public. Thank you.
All right, thank you. Next up, I have Carl Cancino.
I'm Carl Cancino from the Okmulgee Circuit, Post 1. When this all came up, one of the main things that we want to do is we represent the people that we elected us to serve. And in the Okmulgee Circuit, which consists of 8 counties, it's the largest judicial circuit by counties in the state of Georgia. The overwhelming sentiment was, what's the need for this particular action? And in the years that we've been debating this, even though there's been many reasons, I have not heard to this very day whether there was a need for it to be done. And because there's been no finding, or there's been no reason to have it, I ask that you consider option 5, which is to take no action. Thank you.
Thank you. Then I've got Eric Ballinger. Would you still like to speak on the motion?
Bottom line up front, I think we need to take option 5. I echo what Martin Balbuena said. I'm from the Blue Ridge Circuit. Most of my constituents are small and sole practitioners, and of that, most of them do indigent defense work. They're getting paid, $40, $50 an hour to represent indigents. This is to mandate insurance is just going to make insurance more expensive. It's going to be more costly. It's going to paint a target on their back. These are young lawyers that already have a target on their back because they're handling our indigent defense, and people think that they're not real lawyers because they're quote unquote public defenders. And I think that we have not heard anything from the regulatory agency that manages insurance, and note that they don't have to carry insurance for stealing from us their premiums. And so I would ask that, yes, having insurance, good. It's a good idea, but just because you don't carry it shouldn't be mandatory. It should just be a good idea. And while I understand that the public thinks that we all have to have insurance, the public also thinks your doctor has insurance, that your architect has insurance. And I'm sorry that the public is misinformed but why are we any different than the guy who cuts you open and leaves a sponge inside? Thank you.
Right, next up, I've got Lee Davis, and he is participating virtually. So Lee, if you could raise your virtual hand, you'll be promoted.
All right, sorry about that. I am, as you can see, I'm in my home office / music room / everything room. So I apologize. I had kind of anticipated doing this by telephone and not by video, so I apologize. First, I want to say that I am not personally in favor of mandatory insurance, but I do have some what I think are relevant considerations that pertain to the rest of them. And I just kind of wanted to run through those and then propose an alternative idea that could address all of this, I think, in a way that might be a little bit more acceptable. First, I don't think that this question of what we're going to do is going to head off any, or I don't think it's going to create more lawsuits simply for the fact of what everybody has already said, which is everyone already thinks that we are required to have insurance in the first place. So if everyone is already operating under this assumption that we're required to have insurance, the number of cases that we're having right now is probably what we're going to anticipate going forward in the future. Unless we decide that we're going to make it public that we are requiring insurance, then in that case, perhaps it will. But, I would think right now, the level of malpractice claims that we're seeing based on everyone's assumption that we are required to have it is probably what we're looking at in the future. As for the freedom argument, I am a big fan of freedom myself, but I also recognize that freedom is the freedom to govern ourselves in this instance. As with any freedom, as we've seen in the last 2 years, really, the freedom to govern yourself is the one that is most sacrosanct. And if you choose not to exercise that freedom and choose not to govern yourself, someone else will govern you for you. And I guess what I'm trying to say is there's a big push to try to take over the state bar anyway. And I personally would rather have lawyers making decisions for lawyers than, say, the legislature, builders and car dealers and architects and doctors. I don't want them making decisions for lawyers. I think we're in a better place to do it for ourselves. And so I don't think the freedom argument is really quite what should carry the day, because if we act with freedom to not govern ourselves, somebody's going to step in and fill that void, in my opinion. Next, I think the focus of this insurance thing is getting a little bit skewed. Yes, it's there to protect the public the same way auto insurance is, but primarily the purpose of insurance is to protect you and protect you against having to pay a judgment for potential malpractice out of your own pocket, and to pay, more importantly, the cost of defense. If there's a bogus malpractice claim filed against you and you don't have insurance, you're still going to have to defend that claim. I would personally rather have malpractice insurance, and in fact, I'll disclose that I have always had it, because I, like a lot of members of the public, initially thought that we were required to have it. But I have it now because I don't want to have to put my time and effort into trying to defend myself and hiring another lawyer to defend me. And I don't want my own personal assets to be at risk in case I do commit malpractice, because malpractice is just that, it's negligence. It's like a car accident. We tend to commit malpractice, it just happens sometimes. So the focus of insurance really should be to protect yourself first, and then protect the public second. Last, I think there is another consideration that maybe we should think about, and depending on if it gets taken up at all, I think if everything gets voted down today and we do nothing, I think the bar should consider Possibly, if the public perception that we're all required to have insurance is the issue and that's the problem, maybe we should publicize to the public that lawyers are not required to have malpractice insurance. And maybe, the public education is a better way to fix this problem than to require us to do things that we may not necessarily want to do. And, maybe that would solve or at least address the problem and let the public protect themselves. But that's kind of how I see it. So that's it. Thank you.
Thanks, Lee. Now I've got Ken Hodges, Judge Ken Hodges, and he's appearing virtually. Ken, if you could raise your virtual hand, you'll be promoted. Ken, you need to turn your video on if you want. There you are.
Thank you. Thank you. I'm glad to follow Lee Davis. I think he made some great points. And of course, I very much support the bar requiring the minimum mandatory insurance, the 100, 300. If you look on our website and click on the public section about the bar, it says, quote, "The State Bar of Georgia exists to foster among the members of the bar of this state the principles of duty and service to the public, to improve the administration of justice and to advance the science of law." Our first duty is to the public. Our first duty is to the client. We owe them a fiduciary duty, as Mike Terry pointed out. And PLI, professional liability insurance, protects their interests and it protects our own, as Lee pointed out as well. Martin said that we haven't been shown that there's a problem. Well, we showed there was a problem. Lindley Jones showed there was a problem with just one example of the letter from Dr. James Warner. And there are countless others. Otherwise, Lindley and the other malpractice attorneys wouldn't be in business. And so there does, to say there's not a problem is not, in fact, is just sticking our head in the sand. We know that there's a problem. Plenty of lawyers, good lawyers, make mistakes. I've made mistakes in my 25 years. Thankfully, it's not led to, in my opinion, a meritorious malpractice claim. But as Lee also said, the benefit of having malpractice insurance is it provides a defense, even to frivolous claims. I've mentioned this before, but I know we got new Board of Governors members, so I don't mind telling again. I practiced for 25 years, or 27 years before I went on the bench. And right at the very end of the practice, before I took the bench, I was served with a lawsuit that I believe to be frivolous. It was by someone who wasn't even a client for malpractice, but the judge didn't throw it out for that reason. And it took 2 years for the case went on for 2 years and resulted in more than $100,000 in expenses before my insurance company asked me to let them settle it for litigation costs, which we did. And I was just very glad that I didn't have to pay that expense. But if I had made a mistake, like the mistake that the lawyer made in Dr. Warner's case, and my client had been injured, I would have hoped there would have been something there for him to recover with the policy that I had. I've heard that it may be cost prohibitive. I'll tell you, when I was in practice before I left with 2 associates, my annual premium was only $3,500 a year, and that was for $1 million in insurance. So I don't think this is going to be something that is cost prohibitive. I've heard that the costs will go up. We don't know that. You know, there are more than 20 underwriters in the state who write malpractice insurance. With more people obtaining it, it certainly could drive the cost down. But if that occurs, or any other unintended consequence occurs, we can take a vote at another Board of Governors meeting to modify or repeal whatever action we take here today. So it's not something that we can't fix if unintended consequences do occur. I don't have an all or nothing position. In other words, I don't believe that we need to do, if we don't have mandatory insurance, that we shouldn't do something. I think that if that does not pass, then I am in favor of the proposal on the board that Chris made, that we have disclosure. So I do also have concerns about how the vote is going to take place. What if we vote on Chris's motion first, how those of us that want insurance will vote. Although I'm not a voting member anymore, I do worry about that. But I think as a profession, we owe it to the public to carry insurance. And as Lee so aptly said, if we don't govern ourselves appropriately, then the legislature might. I urge everyone to support mandatory insurance, and if that fails, mandatory disclosure. Thank you.
Thanks, Judge. Now I have John R.B. Jack Long. Would you still like to speak? Okay. No, you need to come speak at the podium, please, sir. Thank you.
Oh, good morning, everybody. I'm Jack Long from the Augusta Circuit. You know, I spoke out against this proposal when we first talked about it 2 years ago. I personally have always carried malpractice insurance. I would strongly advise all lawyers to carry malpractice insurance. However, there are some situations where lawyers don't, and that may be okay. For example, lawyers who are in rural areas, providing the access to justice that this body has for so many years talked about improving, that are handling very low dollar claims in magistrate and state courts, or doing a hybrid low bono or pro bono practice, who aren't making a lot of money, who aren't dealing with huge issues. They're not dealing with the merger and acquisition. They're not dealing with the $1 million divorce. They're dealing with somebody in their $500, $1,000 problem. They may not have malpractice insurance. And imposing the requirement for them to carry that is going to make those people not really able to engage in a solo small practice. And again, I think this will affect people, particularly younger lawyers in rural areas. Second thing I'd like to bring up is that rates for insurance have steadily been on the rise. I have never had a grievance or a complaint, malpractice claim, anything like that. Last year, I got a letter that our rates were increasing by 25% due to market forces. I shopped it with every carrier I could find that offered insurance in Georgia, and they were all within $100 or $200 of each other. So what are we going to do about rates, or what, more importantly, are insurance companies going to do about rates when we create a captive market? Now, I was an economics guy in college, so captive markets bring an F word to mind. And no, Madam President, it's not the one you're thinking I'm going to say. Fees. They increase fees across the board. Think about this. Those of you that flew here today and bought a Coca-Cola at Atlanta Hartsfield Airport for $6. Why is it $6 there and it's $2 everywhere else? Because the airport's a captive market. Why is it that when you go to get Bubba Head's new book on DUI law, or the new McConaughey's book on divorce, that it's a $400 book instead of a $50 book? Why? Legal printing companies, captive market. So why in the world would we want to create a captive market for insurers to be able to essentially regulate whatever fees they want to charge us in whatever amounts they want to charge us? If you pass mandatory malpractice insurance, that's what will happen. You'll see fees increase. And worse, what you will see is a cessation of the regulation of the practice of law to insurance companies. Let me explain how that will pan out. You do occasional medical malpractice. Insurance companies find that med mal cases create more claims, and so they start to limit what lawyers they will issue coverage for that practice area to. Or they start to increase fees so as to pressure small town lawyers out of certain markets. Just look at what's happened in the title insurance industry. Used to be most lawyers in small towns could do your real estate closing, your divorce, your DUI, and everything else. Now that all lenders require title insurance, and given that title insurance companies have had some claims experience with some lawyers that don't do a lot of closings, title insurance companies have imposed requirements not allowing lawyers who are otherwise good lawyers, competent lawyers, capable of handling a closing. You can't do a real estate closing unless you have a minimum remittance to a certain level of premium to the title insurance company. I had a title insurance agency for years. I would do an occasional closing. That's how I started out my law practice. I had to give it up because I wasn't doing enough in business. They would not allow me to continue to write policies. And so that is what will happen. This is a solution in search of a problem. To Judge Hodges' point, yes, Ms. Jones provided several anecdotal examples years ago of people that had been hurt, but there are a million of those for every case that we have. I wish that there was mandatory general liability insurance. So every time somebody called me about getting bit by a stray dog from a neighbor, there'd be a case there. I wish that there was mandatory $150,000, $200,000 coverage for people that drive cars and tractors and other things that aren't necessarily required to have minimum coverage. That's not the case. There's some cases that are just not recoverable. Unfortunately, there are some cases where lawyers have screwed something up and the lawyer doesn't have insurance and the lawyer is so down on the luck, they don't have any assets, they don't have anything to recover. But I would argue that those are outliers. Most people in our profession do this because it's financially lucrative, because they enjoy doing it, and because they can be successful at it. We have to date no data, no empirical study, no survey, no nothing that shows we have a problem with uninsured lawyers and escalating claims that can't be prosecuted because the lawyer is insolvent and they don't have insurance. So I don't think this is a good idea. I would like to thank the committee for their 2 years of work. I know it's not been easy. And I know that not everybody on the committee is involved in this space, although I would note that many are. Finally, I would like to mention that until today, I was not aware that a disclosure option and assessments would be at a $25,000 annual cost to the bar. I am absolutely not in favor of increasing costs to our members for something that's not necessary, particularly in a time where we've had, financially hard times for a lot of folks. Across the board, big firm lawyers, mid-firm lawyers, everybody has had their business off over the last 2 years because of COVID. Maybe not malpractice lawyers, I don't know. All that said, I am absolutely against requiring insurance. I'm not in favor of disclosure. I don't think that it serves any purpose other than to sort of foster this cottage industry. And I will be voting against it. To the extent Seth has made a motion, I believe that may have been out of order to vote on option 5, and seeing as a motion on the table has not yet been withdrawn. Madam President, I would at this time move to suspend the rules, which is a parliamentary motion, which I think we can make, to allow debate on Seth's motion first. Again, logically, in order of addressing this issue, we need to first determine whether or not we're going to do anything. If not, that ends it. And if so, then what it is we're going to do. So I would move to suspend the rules to allow entertaining the motion that Seth Kirschenbaum previously made. Thank you.
we don't operate by rules. We operate by bylaws, and Robert's Rules of Order specifically prohibits waiving bylaws. So when you hear about company or deliberative bodies that have rules, it's like a general assembly because their bylaws will be the Constitution. And obviously, they can't run a meeting that way, so they have rules. We don't have meeting rules, so there's no rules to suspend. Specifically says that bylaws may not be suspended.
Thank you, Mr. Long, for your comments. Now we're going to go, we've got some folks on Zoom that have raised their hands. So what I'm going to do now, just to set the stage, is we're going to go back and forth a little bit between people on Zoom and people here. So first I've got Ed Tolley's hands raised. So if you'd still like to speak, they could promote him. Sorry, Cal. Ed, to the extent you can hear us, we've sent you a request. If you could accept it, if you'd like to still speak. Okay. You just need to, there you go. Thank you.
As you can tell, I'm not very good at this, and I really don't have anything to add to the many fine comments that have been made. Like others, I appreciate the efforts of the committee, but as they say in the rural parts of Georgia, this dog just not going to hunt. I don't think this has any possibility of passing. I think it's a problem, it's a solution in search of the problem, and we should pass it. That's my only comment.
Thank you. If you'd like to.
Hey, good morning. I'm Randy Davis from the Cherokee Circuit, which is Bartow and Gordon counties, and we've got about 175 members. I'm probably, to the best I could tell, the only in-house counsel in the entire circuit, and I've tried to be responsive to my members and keep in touch with them, and they have certainly shared their thoughts on this on PLI with me, which has been an overwhelming negative response. And I just wanted to be sure to represent my constituents and share that thought with you. And I think if I had to summarize their substantive positions, I think it's already been well stated by Seth and Eric. Thanks.
All right, on Zoom, Will Monahan's hand was raised. Will, if you'd still like to speak, got him, he's there. Okay, thank you.
Thank you, Madam President. My name is Will Monahan. I represent Out of State Post 2 and somewhere in the neighborhood of at least 7,000 members who are active Georgia bar members who reside outside the state. If you'll turn to page 112, which is option 2, it regards the exemption language on line 76 and 77. And this exemption language is the same, I believe, for all of the options. So I'm speaking on behalf of all the options. Presently, it talks about members who are not actively engaged in the practice of law or who do not represent clients. And I would move to strike or who do not represent clients to bring it in line with the CLE exemption language that's in Rule 8104C4. So what I would propose is for members who are residing outside the state of Georgia, that this language mirror the CLE exemption language. What I don't want to happen is to lose a bunch of active members outside the state of Georgia who neither represent Georgia clients nor have practiced in Georgia within the bar dues year. And so the motion that I would move for on all the exemption language that's contained in each of the options is as follows. For option 3, which is line 76 and 77 on page 112, it would now read members who are not actively engaged in the practice of law, semicolon. It would strike the remaining portion, which is striking or who do not represent clients. So it would read members who are not actively engaged in the practice of law, semicolon, and 4, active members residing outside Georgia who have neither practiced in Georgia nor represented Georgia clients, period. And again, that would apply to all the options.
Yeah, one, what we're gonna consider, that's a motion to amend. Okay,
Yep.
so that's, and it needs a second. Okay, and then we need you to repeat the language again slowly, or if possible, email us the language.
Madam President, I can actually put that into the chat
Yes.
right now. Does that work?
Yes, we got it in the chat.
Okay. Should I send that out to everyone, actually?
Yes. Put it in the chat, send it to somebody, and then we're gonna reread it too.
Okay.
All
Very
of
good.
the above.
Thank you very much, Madam President. That's all I have.
Okay, thank you.
Thank you.
So if you'll just give us a second, we're gonna get the language so that we can have everyone look at it so that because we've got a motion and a second to amend the motion on the floor. And then once we get the language, we can have debate on the amendment and vote on that motion to amend, and then we go back to our normal course. So we're just gonna press pause for a second while we get the language where y'all can see it. Accepted. You don't. No. So what we're discussing is you don't have to accept an amendment. We've done that for years and that is incorrect. Yeah, so we actually, when you make a motion and then you've got to vote on the motion to amend. We're getting the language together. We're going to put it on the screen for everybody. All right, so on the screen, you see the proposed language to amend basically all the disclosure language. So that would be for lines 76 and 77. Any discussion, any comments on Zoom or otherwise? Oh, everyone's reading. I'm gonna let them keep reading. Anyone in the room have any comments or questions regarding the proposed language? Yes, Mr. Long, you got to come to the front.
Who is going to monitor all these exemptions? Is that Paula that's going to be doing that extra work, or who at the bar is going to be figuring out for all these out-of-state folks that may be exempt and all the people that may be a government lawyer or this or that, whether or not they're exempt from this requirement and who's going to have to follow it and who's not? That's my question.
Good questions. Anyone else have any questions? Some questions don't get immediate answers. Oh, sorry. Okay. Get him first, and then we'll get Judge Cannon next. Okay.
Just to clarify, if we make this amendment, is it saying that the state bar wants Georgia citizens to have an attorney that has coverage, but we're okay if a citizen of another state has a malpractice claim against our bar member, and we're okay with that person not having coverage? Would that be the outcome of this rule? That's the question.
Okay, we have to stop sharing the screen to get Will back up on Zoom. I'm actually sorry, Judge Cannon. I'm gonna let Will go. I'm gonna let the proponent of the rule respond to the questions. So we're going to Will Monahan again.
Madam President, thank you. With respect to the mirroring of the CLE exemption language, somebody asked, how are we going to monitor this? And some other people raised other issues. By mirroring the CLE exemption language, that already covers our out of Scott McMillan and out of Post 1 and my out-of-state members. These members are active currently, and it's automatic. The bar already knows who's an out-of-state member by their designation for an exemption that already exists under the rule that I provided, which is 8-104C4. That already happens. All we're doing here is mirroring it so that the professional liability that Georgia wants to protect its citizens. Those citizens are within its state borders. Georgia's purpose, and hopefully the bar's purpose here, is not to protect the citizens in California. It's not to protect, people in Minnesota. It's only to protect people within Georgia. And that's the reason I believe, and Bill Neesmith, of course, can expand on this, But that's the reason I believe that Rule 8104C4 exists, providing the CLE exemptions to begin with. All we're saying is if mandatory insurance is going to be required, that somebody who has clients within the state of California but happens to have an active Georgia bar license should not be required by the state of Georgia to protect California citizens. It's pretty straightforward, it's simple, and by mirroring language that already exists, the general counsel's office for the state bar can easily and without really any additional cost, it can be monitored seamlessly. Thank you very much for your time.
Cannon's. I've got Judge Cannon on Zoom. Judge, you're muted.
Sorry, I hit the button and then it required me to respond. I'm in the middle of a multi-co-defendant murder trial, so I'm not my normal chipper self. All I was trying to do is ask the question I put on the chat and tried to send a question to the group about what would pro hac vice requirements be. And I would guess the rule should have something similar to that rule, but say that if you are representing a client in Georgia or admitted pro hac vice, you should be required to either disclose in your application, or if we require coverage, be required to have the coverage that we require for any lawyer in the state. But have anyone even thought about that?
Hey, Judge, send an answer separately. I'm sorry about that. I don't know that this was a consideration in the original committee evaluation process. And I'm wondering if this is your request to amend and have that as consideration.
I'm inquiring how they would be covered and would they be required to cover under what the current proposal is, or we'd have to promulgate additional rules to determine how they would be covered and how they would disclose, et cetera. But there's a lot. I just think there's a lot of issues that we have not thought of, and that's one of them.
Yeah, Judge, you're right.
So that's all I got.
Hey, could we get Will Monahan back up? Sorry, Will, in case you stepped away from your computer.
Madam President, thank you. I'm here.
Will, thank you very much. And I appreciate that amendment. And I think we've had a good debate. I'm going to ask Will if you would consider withdrawing your amendment with the understanding that if you withdraw your amendment, I'm going to withdraw my motion and request a motion from the floor and a vote, and then we'll know which way we're going to move. But I can't withdraw until you withdraw your amendment.
Chris, I'll be happy to withdraw. Your motion again is, just to restate.
It was option 2.
Option 2.
So are you withdrawing your amendment on the out-of-state rule? Or
will I be able to re-raise it after you have your motion?
Yes, you will.
Okay.
If that's necessary, yes, you would be able to.
Then I request it automatically be raised after the motion, Chris's motion has been ruled upon. If that works, and if that's fine, then I go ahead and withdraw. Thank you.
Thank you.
Madam President, at this time, I will withdraw my motion for the adoption of option 2, and will ask that you call for a motion from the floor.
I have such a motion.
I imagine you do. Mr. Naismith, do I need to do anything else? Thank you, Chris, for all your hard work. Mr. Long, please. You like being in front of people, so be in front of people.
Madam President, I would like to move that we vote on option 5, which is to simply do nothing and to thank the committee for their hard work and to sunset this committee. excuse me, our parliamentarian has given me, I have worded that wrong. Let me rephrase. My motion is again to thank and sunset the PLI committee and to reject all current options that the committee has come out with, which is in essence, option 5.
Okay, I have a motion in a second. Any comments from the room? I'll start with the room and then go back to Zoom. It's another motion. Just give it a second and it'll probably happen for you. Any comments from anybody in the room? Anyone on Zoom with their hands up? Okay, so James Irvin has his hand up on Zoom. Let's promote him and see if he's still interested in speaking. This is truly Festivus.
James, we see your name, but you need to unmute your audio and turn on your video, please. We can hear you and see you now.
Do you have any comments you would like to make? Okay. James, do you have any comments you would like to make? Okay, I think we need to take him down. And then my understanding is Lee Davis may still have his hand up and want to speak on something. Technology is fun. Thank you. Thank you, Lee, for reading the room. Okay, so Solicitor Gamage has his hand up. Could we promote him if he's still interested in commenting?
Good morning, colleagues. It's probably rare that a prosecutor will weigh in on this particular issue, but the foundation of what I do in my job daily and nightly is rooted around public safety. And it just seems to me that, and I understand there's some disagreement about how to accomplish it, but it just seems to me that malpractice insurance is a component that helps to keep the public safer. And so I simply suggest that it's the right thing, very contested issue, but hailing from the Atlanta Judicial Circuit, I want to share that opinion that I believe we should, as lawyers, even though my practice isn't civil, that there should be a net for people. And I think the public deserves it. And so I thank you all for hearing my comments, and certainly thank our leadership and our members for engaging in this very important issue. Thank you.
Thank you. Any other comments in the room? All right. As at this point, we have a motion to reject options 1 through 4 of the committee. We just need a second because we've got to draft that language. Oh, into sunset. Yes, Mr. Fennell. Second what? No, we've got it. We need a moment in time. Sorry. You know what? Thank you. We need a moment to actually draft the question and get it on a slide so then that we can vote on this issue. Just keep seconding all day. That's some good music. Real quickly though, please make sure that if you have a clicker, you are not logged on the app or on the website. If you're only on the app, don't be on the website. Please double check that you aren't on multiple devices. Our secretary would really like to find another roll sheet. We're missing one. So, oh, he's got two. Nikki has one. Nikki's the trouble. Yes.
I've been kicked off the app. And when I try to log back in, it says the session is full.
So that is why we need to make sure that everybody has logged off. Of multiple devices. If you were on, if you just wanted to see what it looked like and logged on and then wanted to use your app, just close your browser, make sure that you're not on multiple devices. Folks, as we figure this out, we're going to pause the meeting until 11. So we're on a break. You got 8.5 minutes to go talk to Jack about his life. All right, everyone, if I could get everyone to take their seats, and you also might need to re-enter your information if you're using the app or the website. We just restarted it for the group. I'm back in. Yeah, yeah. All right, do we have the folks back up? Hey, Damon?
Yeah, but then they have to fly back up.
You ready? Okay. Hey, everybody. We had a brief intermission to deal with technology. I'm not upset with intermissions. They're kind of nice to take a break. Yes. Officers are getting in trouble up here. All right, so well, no. We've got folks at Zoom, we've got folks in the room, so yeah, please log back in to the way in which you were using it. If you've got a clicker, you're good, but if you're using the app or online. poll together. Correct. Okay, everybody. We've had an interesting development insofar as someone on Zoom has moved to table this issue until the annual meeting. So far, it's only a motion. There has been no, don't say it. There's been no second. So there's no second. All right, we're back to the original motion. Okay, are you ready for the poll? Okay. You're ready, everybody. Leave it open for a handful of seconds. Yes. We have 108 votes. All right, we are going to close it in 10, 9. Uh-oh. Our president's report's only going to be like 45 minutes, maybe. I'll trim some off of it. Oh, I know. Oh, I know. Tony Del Campo's report's going to be 35, 40 minutes too. Yeah, same, hard same. Oh, yeah. I'll just say, I'm the president. Here's my report. Definitely. It's a joint meeting.
Vote on which was better.
Okay, we're closing the vote. Ooh. The motion passes. We're gonna just leave it up for a second, so sorry for a moment. Just people need to see it. Next up, we have Secretary Ivy Cadle, who's going to report on the Client Security Fund.
Almost feels appropriate to say good afternoon, but it is still morning. Onward to the Client Security Fund. We've packed this meeting with wonderful controversial topics. So as secretary, I serve on the executive committee as the liaison to the Client Security Fund. The other members of the Client Security Fund are Taronia Smith, who's our current chair, I believe. David Cook's our vice chair. Trustees, LaToya Bell, Michael Joffroy, Von Hicks, Bob Coffin, Sammy Strode, and then Bill Neesmith is our Office of General Counsel liaison. If you recall at the annual meeting, I made a general presentation about the Client Security Fund. At that meeting, Mr. John Pennell and some others asked for additional information. We gave an update in about mid-September that had several things. And so I've got some detail today that I want to run through just so everybody remembers what we're doing and why we're doing it, and we'll talk more. The whole point of today is really to figure out whether or not this board wants to continue the client security fund. And I will preview that I'm going to make a motion that we do so, and that we do so at $15 per year, because that is what the client security fund trustees have recommended. So two kind of divisions of what I'm going to talk about. That's perspective and action. So for perspective, the mission of the state bar is to protect the public. This fund is a program that directly protects the public from unethical lawyers. If we only pay claims that are approved by the trustees. The trustees only consider claims where there is a misappropriation, theft of client funds, be it a retainer paid for services to be rendered that never got rendered, or be it a settlement that was never remitted to a client. These attorneys are disbarred, and these attorneys cannot be reinstated unless they repay every dollar that was paid out by the client security fund. Perspective, historic source of funds. Historically, under Rule 1-506, we have charged each new lawyer $100, payable in $25 installments over the course of 4 years. That has generated about $200,000 a year. The fund pays out $500,000 a year. There's information in the board book that shows you what they've paid, I think going back to 2014. All that information, if you want to look through it now, starts on page 121. So we've had stopgap funding. We got $388,000 from CCLC in June of 2020. Before that, there was a $500,000 infusion of capital from the general fund. And then we moved $1 million from the ICLE indemnity fund in March of 2021. The purpose of that significant transfer was to allow us the time to have this discussion before, under our current rules, if the fund balance goes below $1 million, we will assess every lawyer in the state whatever amount is needed to bring it back up to $1 million, so long as that amount is $25 or less. So if we do nothing, the fund will dwindle below $1 million, and then we'll just follow our current rules that say assess everybody whatever we need to make up the balance. In my mind, the threshold issue is, do we do this assessment or not? And I think that kind of leads to, if we don't, then we've got our answer. If we do, then we have our answer. I have sent out, Bob Kaufman had a February, and all this again starts on page 121 of your board book. You've got a letter from me that's short. You got Bob Kaufman's February 2020 memo about more information. You've got Bill Neesmith's annual report. You have Scott McMillan, who is an out-of-state member from Florida. They recently underwent this transition. In rough numbers, they've got about twice as many members as we do, and they voted for a $25 assessment. So he gives you the historic, what's going on there. And he also does a real good job of kind of narrowing down adjacent states. So I found that super helpful, and thank you for preparing that, Scott. Much appreciated. There is historical data from 2013 through May of 2021 that gives you a dozen or more data points for each one of those years. And then there is questions that I came up with that in looking at the data, there were abnormalities and trends. There were things that I thought, just questions that I had. And so I went ahead and posed those questions on your behalf to bar staff and said, hey, what about this? What about that? Could you give us a little more color behind this information? And then there's a spreadsheet of claims to this, an answer to my question. So you've got all that information. We've talked about this in the annual meeting. And so today, kind of much like lawyer malpractice insurance, we wanted to bring this for a robust discussion to see what the will of the body is. And so the action step will be eventually here to consider my motion, should it receive a second. And then There are a lot of questions about client security fund. There are people who, as I've worked through this and talked to the court, there are people who in this body and others who question, should we have a client security fund? Is it doing what we want it to do? Or is the why appropriate? One way I look at it is we have a fitness board to get into the bar. If you're not fit or if you have significant financial problems, you will not be considered for admission as an attorney for the state of Georgia. We don't have any kind of continuing fitness program. When it comes to malpractice, that's usually seen by other lawyers. If somebody misses a filing deadline for a complaint and the answer just doesn't show up, somebody had to file a complaint and know that an answer should have been forthcoming. And so some of the more negligence type things that are adversarial, there's another lawyer on the other side who has the ability to see that that had happened. And at some point, you know, there's some social forces or there's opportunity to report something. Client security fund, on the other hand, pays claims where a lawyer has actively hidden their bad acts. And so while it's not a perfect program, while there are limits on what we pay out, to some degree, this is a way to look at the fitness of a lawyer, and instead of going to fitness every 5 years or something like that, we have a fund that pays out on claims. If we have this annual assessment, we're also going to have to change our rules. This will have to go up to the Supreme Court and be ratified by the Supreme Court. I don't have any way of knowing what the full court will do. We have talked about this with them and had a very similar conversation in our joint meeting, so they know that this is coming up and are abreast of it. But ultimately, the longevity of the client security fund is whether or not it has money to pay claims. And so that's kind of why we're bringing this up in that form. There are good arguments on each side. I'll be interested to see what this body does. And with that, I would move that we assess each member of the State Bar of Georgia and Pro Hoc members an annual $15 assessment to the client security fund.
Thank you, Mr. Cadle. All right, just like we did before, we've got a motion in a second. I've got people who signed up in advance. I'm going to go through those first, and then we'll do the tag team. We'll go from Zoom, in person, back and forth. So Eric Ballinger, do you wish to be heard on this topic still? I respect you. Let the record reflect. I've got Clayton Tomlinson. Would you still? Excellent. All the respect, because you came to the podium without being told.
Thank you, everyone. I will be brief. My name is Clay Tomlinson. I represent the Alapahaw Circuit, and thank you again. I do want to say that everyone wants to champion a victim. That is a good thing. Georgia actually has statutes. We have the Georgia Crime Bill, Victims Crime Bill. I also want you to be aware that if you're not currently, because what we're talking about here is thieves. We're not talking about innocent attorneys, good attorneys. We're talking about thieves. And I don't personally like a thief. But our state has a statute called restitution. And if you are convicted of a theft, the victim can request restitution. You can have a restitution hearing, and probation is supposed to collect restitution. Currently, the Georgia Department of Supervision's policy on collection of restitution is below weak. That's an issue. That's not this board's issue, but you need to be talking to your governor, your legislature, the Supreme Court justices about criminal justice reform, and let's champion victims and make restitution a true issue. And make the thief pay his own debt. I watched Robin Hood as a child, loved it. Robin Hood took from the cruel, unjust king and gave to the needy poor. That is a champion idea. there reaches a point where I don't think it's right to keep taking from 52,000 innocent attorneys to pay a fees debt. I'm not saying we should get rid of the client security fund, but think about that. Think about what is the true problem and what is a just answer for our innocent members. Thank you.
Thank you, Judge. Now I have Martin Valbuena. Good job.
Thank y'all. I'll be brief too. In the programs committee, you've heard me say, I think several meetings now, 3 years ago now, we did the assessment over all the different programs. And there were several programs that got what I would call fairly poor ratings. One of those was the Client Security Fund. Another one of those was the fee arbitration program. And the goal we had was to tell them, you got a poor rating, here's why you got a poor rating, go figure out a way to fix it. And I think we, earlier this morning, we dealt with the fee arbitration people, did their assessment, came up with how they wanted to change the rules to make the program work better. And we've gone ahead and adopted that to sort of see if that's going to work or not. It may work, it may not. We hope it does. I think it boils down to what Ivy just said. The Client Security Fund has done the same thing. This is their proposal. What Clayton was just saying was he doesn't know if we should do away with it. Well, I think what Ivy said is more correct, is that you either do this or you do away with it. It's not working the way it's constituted right now. So we either have to get a fund, which is basically a tax, and you have to say, we're going to tax everybody to pay for these fees. I think Clayton's right with that. And the difference, I think, between this and the PLI debate is there is a demonstrated problem here, because you can look at the numbers that Ivy put together that show how many claims come forward every year and what the amount of money that's being stolen is. But I think that's what it boils down to. You either want to keep client security to help protect them, and then we're going to have to pay for it, or we do away with it and we don't have it anymore.
Next up, I've got Scott McMillan.
Thank you, Madam President. I'm Scott McMillan. I'm the other out-of-state board member. I'm from Florida. So my constituents are the same 5,000 or 6,000 out-of-state lawyers who pay active dues to the Georgia Bar. I had the privilege of serving 6 years on the Florida Bar Board of Governors. And during those 6 years, I also got to work really closely with the Florida Client Security Fund. And I got to see how well it worked. And I was very impressed with it. I loved it. I am speaking on the Georgia Client Security Fund behalf because I think it's a terrific program. When you think about it, the first thought is the Client Security Fund is designed to protect the public or the consumer. And that's true. And that's probably the primary reason for every lawyer regulation that we have in any bar is to protect consumers. But my experience with the Client Security Fund is it also protects us. It protects lawyers. It protects our reputation. What happens when a lawyer steals $5,000 from 5 different clients? Each of those clients tells 100 people that my lawyer stole $5,000 from me, or my lawyer stole $5,000 from my grandmother. And those stories are terrible because those 100 people tell another 100 people about the lawyer that stole $5,000 from 5 different clients. Having the Client Security Fund in place changes the story. The story becomes, my lawyer stole $5,000 from me, and you know what? The bar took his license away, and the bar refunded my money. Those are the stories that we want circulating to those hundreds and hundreds and hundreds of consumers that hear about the lawyer that steals money from his client. That's good for us. We all know that lawyers have a reputation problem, and client security funds help that a lot. In the board book, I did a survey. Actually, I did a summary of the survey that the American Bar Association did on client security funds around the country. And most bar associations have them. And the average annual dues across the country is $25 a lawyer, but a lot are higher. That's the average. Very few are as low as $15. But if we can charge baby lawyers $25 a year for the beginning 4 years of their practice, and they can handle it, then lawyers who have been practicing 5 years or more ought to be able to handle $15. That's nothing. I almost decided to move to make it 20 or 25, but I want to see it pass because I'd like to see the Georgia program continue. That's the only reason I'm not making a motion to make it $25 a year. Thank you.
All right, that concludes the folks that signed up in advance. Do we have anyone in the room who'd like to say something? Oh.
I'm Susan Cox from the Geeky Circuit, and I just want to respond to the restitution idea. I think that's a great idea. I completely agree with that, but I'm representing a family where a well-respected estate planning lawyer here in Savannah, who actually was my classmate in law school, set up a series of family trusts after this entrepreneur sold his business and then systematically looted about $8 million out of those trusts. And right when he was about to be uncovered, he killed himself. So there won't be any restitution from this lawyer. His wife knew nothing about it. She's not going to be responsible for what he did. So I agree that restitution in theory is a wonderful idea. It's just not going to work in practice in every instance. And I do thank you, Scott, for the information you provided. I thought that was very helpful. And so I hope we will vote. $25,000 is a drop in the bucket for this family, but at least they know that the bar did something to help make it right, because the guy who made it wrong is not around to pay the consequences. Thanks.
Excuse me, I'm out of the Macon circuit. Anyway, I actually was about to say the exact same thing. I've been prosecuting for 27 years, and bleeding turnips is not very easy, and has gotten any easier in that time. And so, yes, again, the restitution idea is wonderful. And if we can get that, great. We should absolutely go for it. But I am all in favor of, yes, of beefing this up and taking care of the mistakes of the people around us.
My understanding is Judge Whitaker has her hand raised on Zoom. Got her.
Good morning, everybody. I am absolutely in favor of this as well. I just looking at the materials, it looks like there are several jurisdictions that have various exemptions. And I wanted to consider an amendment to Ivy's motion to exempt government and pro bono lawyers from the assessment.
All right, so we have a motion to amend. That would require a second. Do we have one in the room? Yeah, we got, I'm sorry, Judge Whitaker, can you restate your motion one more time?
To amend Ivy's motion to exempt government and pro bono lawyers from the assessment.
Hold on. What? Yeah.
I just want to be sure before what the motion is to include government lawyers.
No, to exempt them. It looks like the way it's written that the assessment would be to every lawyer.
Dues paying lawyers, yeah.
And so she wants to exempt government and pro bono lawyers from the assessment. All right, and we have a second on that. So at this point, we get to debate the motion to amend. So, Madam President. Okay. Gotcha. We've got a question, and Ivy's going to restate it and address it. Nope, you got it.
Madam Past President asked a good question, and that is how much would what is the net dollar effect? And I will tell you, I don't know. I don't know how we track that, but the $15 per lawyer was calculated by the trustees of the Client Security Fund and coming up with this recommendation by just simply multiplying $15 times all the lawyers. And I think that comes out to right at $600,000 a year. And so the fund pays out $500,000 in claims in most years. And that's under its rules, the most it can pay. And so there's potentially $100,000 margin there. And the math to how this affects that margin, I don't know. Yeah, if you've got, Bill's got something. He can tell. Hang on. Mr. Neesmith pointed out that we have a lot of part-time judges, and so there are a lot of people who have some sort of governmental, judicial, whatever aspect of their overall professional life. And so to the degree they would be included. Yes, Mr. Pennell, do you have a question? Dues paying members. So if you're inactive, I don't think you pay yet. All right, yes, then yes. All right. All right, yes. I do what I'm told, yeah. Judge Whitaker, there's a question in the chat or the Q&A. And could you? Yeah, who are the pro bono lawyers? Are they public defenders?
Yes.
Yeah, the GLSP.
But they'd also be government lawyers to begin with. And I was
about, like,
contemplating
GLSP?
full-time, not part-time.
Okay. GLSP.
Yes.
I was told I have to ask the person who made the motion. Any others? Thank you.
Well, hold on, Mr. Pennell, could you come? Thank you.
I have all the due respect in the world for our judiciary, especially Judge Whitaker. But I would kindly ask that this body vote down this amendment. I think if we're going to assess anybody, we need to assess everybody. And it needs to be bar wide, just like you assessed when you become a lawyer for the bar center. Everything else, it needs to be equal for all paying members, not exceptions for certain types of members of the bar. Thank you.
Scott, did you have a comment you wanted to make? Can you come to the podium, please? Thank you.
Thank you, Madam President. What I noticed was in the board book, there's a proposed rule change, and it references lawyers who appear in our courts pro hoc vici. And I don't understand whether the initial motion to raise the dues to $15 on all dues paying members includes pro hoc vici lawyers. They do have to pay something when they get approved to practice in a case. It includes them. Okay, that's, I just wanted that clarification.
Okay. So what we have to do now is we've got to quickly insert a motion to amend into the software. If you're online, just don't vote on anything yet until I tell you it's actually voted. The way the software works is when something is advanced, it looks like it's open. We're not voting on anything right now. as we work through the technical issue on that. It should be a lot faster than the last one. But on the table before us will then be a motion to amend to exempt government and pro bono attorneys from the assessment. So, Judge Whitaker, if you were still here, we received a question in the Q&As that what was the purpose of the exemption? If Judge Whitaker is still available.
Well, having lived in Atlanta my entire life, or practiced in Atlanta my entire life as a government lawyer, most of it, it did seem to me that government lawyers make less than most, but I see a whole lot of people in the chat saying that a lot of government lawyers make more. But that had been my thought, is to just give them a break.
Thank you. I need everyone to stop voting. If you're in the system and you're just poking around, just stop for a second. Y'all are anxious.
And if I could add as well, a lot of government lawyers don't have their bar dues paid by the organization that they work for. They pay them out of their own pocket. And I don't think that's true for most attorneys in private practice.
Thank you. All right, so she's about to put the amendment, the motion to amend in the polling software, and it will be live for voting. All right, so the motion is live. The motion to amend. We're good? All right, we're going to be closing the poll in 2 seconds. 1, 2. It's closed. All right, motion to amend fails. All right, now we're back to the main motion. Oh, the people online can't see, so the motion fails, 14 in favor, 96 opposed. So now we're back to the main motion. Any additional comments on the main motion? Anyone in the Zoom with their hand raised? We're not voting yet. We are not voting yet. Judge Cannon has his hand raised, so if we could promote him so he can make his comment. Are we good? Okay. Judge Cannon, you're muted.
God, you would think after doing this for 18 months, we'd figure it out. All right, one, I'm in the middle of a murder trial, if y'all didn't hear me earlier, and did not drive to Savannah, and am still in my pajamas. So I apologize for my appearance. I would have told you not to do me on the video if I could avoid it. I have some serious concerns about this just in general. First, should we not just let the current funding mechanism that is in place kick in first before we try to change it? Second, shouldn't we identify a problem and then also look for other funding mechanisms? Part to Judge Whitaker's motion, I'm not addressing in favor of it or not, but that's something that other jurisdictions have in place. We are one of the few jurisdictions that penalize our younger lawyers the most and make them pay the highest in dues, and do not give a break for other jurisdictions give breaks for younger lawyers and for government lawyers. We do neither, and instead make our younger lawyers pay more dues than our older lawyers do. I'm presuming that this rule, if proposed and passed, will remove that additional payment by the younger lawyers. So I'm not certain about that. That's another question I had. Should we not look for other funding mechanisms first? Other funding mechanisms such as CLE, ICLE, CCJC, whatever the organization is that collects the $4 an hour fee, which currently generates somewhere between $2.5 and $3 million. I have maintained the entire 19 years I've been on this board that is really part of our bar dues, but no one says it. So we're currently pay more than $300 a year in bar dues to the bar. Other jurisdictions throughout the country either include the CLE fees in their bar dues or don't have a fee for that at all, or have a minimum, very small $25 fee. We generate $2.5 to $3 million, and I have continued to say that I will do it for half of what we collect, and I will retire, and y'all can just pay me, and I'll monitor the 50,000 lawyers' ability to practice law by having their CLE hours in effect. Another thing we should consider is another funding mechanism such as pro hac vice fees. Pro hac vice fees currently go to Georgia Legal Services, which is not a bad program. It's a great program. It's a wonderful program, but that would be a tax on out-of-state lawyers so that we wouldn't have to charge our lawyers more. So that should be looked at as a funding mechanism. Our budget has tripled since I have been on the board, tripled. And that's after we have paid off the bar building. What if this is a good program? It's a great program. It's a noble program and something we should continue in some sort of fashion. But what if every program in existence came to this board and said, we need a 3 to 4 times increase in our budget? What would we do then? And I have a concern that the proposal would be for us to increase everybody's bar due $150. So those are my concerns. Thank you.
Thanks, Judge Cannon. I think Ivy's going to address an additional point or two, and then we're probably ready for a vote.
Thank you, Judge. We did get $388,000 from CCLC. We don't have any assurances that any more funding will be coming. So that has been considered. To file for client security fund relief, the claimant must have exhausted all civil remedies, and we do frequently get restitution, for instance, if you've got a member who wants to be reinstated. So that does in fact happen. And the intent of this motion is in fact to take the burden off of new lawyers, to get rid of the $100 fee. This would be $15 everybody. So instead of paying $25 for 4 years over their first 4 years, they just pay the $15 like everybody else. We get and Bill says we get restitution from the courts too. So, a lot of moving parts.
All right, with that, we have a motion on the floor to impose a $15 per dues paying lawyer assessment and pro hoc vici. So with that, are you ready? We're going to open up the polling now. Can you give a 5-second one? You good, or do you want me to? We'll be closing the polling in 5 seconds, I was told. 5, 4, 3, you get it. Polling close. And the motion carries with a vote of 102 for and 14 against. All right, as a result of that, we have some rules changes related to. That is not Ivy's responsibility. Mr. Neesmith is going to tell us about that.
Okay, well, 14 of you didn't want to see me, I guess. If you'll look on page 121 of your board book, there is an explanation, I guess, of what it is that we're trying to do. Let me find the rules are. Yep, 147. What happens when I have something marked and then, yeah, 142, you'll see I've done a memorandum of what they are, and the problem that we've had with client security fund, the way it's been before, is that it had all these artificial caps and it made us sit on a bunch of money, and just the way the fund should be is just kind of the way a business works. You can spend what you bring in, but no more. And that's what this does. It takes the burden off of the younger lawyers. They don't have to pay anymore. And then whatever the fund brings in, it can pay out. And if it can't pay it, if it ain't got the money, it can't do it. And so that's what the 1506 is, the one that removes the assessment from the younger lawyers. And then 10103 is the one that takes that artificial cap of having to have $1 million just sitting there. $1 million sitting in that account. So that's what this is. And this will make it where I guess it's fiscally responsible, where it can only spend what it gets. I'll be glad to answer any questions. Good, thanks.
Well, for the polling, is it one vote for the two questions? All right, so right now I'm just looking for a motion to approve the bylaws changes as presented. And I believe for our polling purposes, they're set up as two different. We'll have two different votes on that. So I need a motion to approve 1506. Got a motion and a second. Any discussion? Are you serious? Oh, please, please come up here.
So the body of the proposed bylaw or rule change is on page 147 of the board book. And it appears to me that it doesn't make it clear that Pro Hac Vici lawyers have to pay the annual dues or this $15 every year. Their case is going on and they're still admitted. And so here is the language change I would propose that we make in this. Section D, the sentence could be changed to read, lawyers admitted Pro Hac Vici to the various courts in Georgia shall be responsible for paying the assessment upon applying for Pro Hac Vici admission, and then add these words. And then annually thereafter until they are no longer appearing Pro Hac Vici in any court in Georgia. Just to make it really clear that they've got to pay every year, just like other lawyers, as long as they're admitted to practice Pro Hac Vici. And if you're going to do that and charge them, I think that subsection B doesn't have any penalty on Pro Hac Vici lawyers for refusing to pay. So I would think we should change subsection B to read the failure of a dues paying member, then insert, or a lawyer admitted Pro Hac Vici to pay the assessment shall, et cetera, et cetera, et cetera, be subject to the penalties. So I just wanted to clarify that they're included every year that they're practicing here, and they are subject to penalties if they don't pay.
It's okay. The only reason it's written the way it is because we really don't control Pro Hac Vici. That's controlled by the Supreme Court. And well, through the Uniform Superior Court. Code. Yeah. Yeah, it's fine. I'm just saying that.
Clear on the language? So those two tweaks are, okay. Okay. So on the table now is a motion to approve the rule changes 1506 as amended. Language only known, charge and all kinds of all right, so we can open the polling. Yeah, we're voting now. All right, we good on the. All right. 5-second warning, but I'm not counting. Right, right. Thank you. Yes, we know that the poll says as presented, and we know it means as amended. Let the Zoom recording reflect. So we're good? We call it. Yes. All right, motion carries 1064, 3 against. All right, I need a motion to approve Rule 10-103. Perfect. Any discussion? Online or otherwise? Anybody got the hand raised? All right. We are going to vote on a motion to approve Rule 10-103 as presented. Okay, I'm gonna get 5 seconds. And then we'll close the poll. All right, motion carries in a vote of 103-3. All right, moving on in the agenda, we have appointments to the Commission on Continuing Lawyer Competency. They're reappointments of Donna Hicks and Jeff Ward. I need a motion to approve these reappointments. Any discussion? All right, we can publish a poll. All right, we're gonna close it in 5 seconds. Motion carries 90-3. Those last 3. It's just fun. All right, I need, next, we got appointments to the Formal Advisory Opinion Board. The one and only Martin E. Valbuena is being appointed to the Formal Advisory Opinion Board. Do I get a motion to approve? I hear a motion in a second. Any discussion? Anybody want to talk about Martin's qualifications? All right. All right, you can publish the poll. All right, we're gonna close it in 5 seconds. Ooh, Martin. Sorry, maybe Martin voted against himself. Motion passes 93-4. All right, now I'm calling up Kyle Williams, the chair of our advisory committee on legislation, to give an update.
Good afternoon. I'm Kyle Williams. I'm the chair of your advisory committee on legislation. I am not expecting a healthy debate on anything. We held our first meeting September 14th via Zoom. We have our next meeting November 30th at the Bar Center, where we will set the final State Bar's 2022 legislative package. During the meeting in September, it was relatively light. There was one matter before you for consideration. The committee unanimously approved one proposal to support continued state funding for legal aid grants. The only proposal before you today is from the committee to support inclusion in the profession. The materials can be found in your board book on page 147. The committee requests that the board support the Judicial Council's fiscal year 2023 budget request of $3 million to fund civil legal services grants for victims of domestic violence. The background here, the State Bar has previously supported this annual funding request for the last 20 years. The legislature reduced that appropriation by nearly $1 million in June 2020 due to pandemic-related budget cuts. This restores those budget cuts. The appropriation for the grants increases that roughly 1.6 to the $3 million. The committee, my committee, our committee voted unanimously to support this, and we would ask you all's respectful consideration of the same and support. Happy to answer any questions. Otherwise, I will turn it over to Madam President for the Keller vote as well as the vote on the proposal.
So first, we would need a motion, a Keller motion on whether or not it is germane to the scope and purposes of the bar. Do I have that motion?
So moved.
Thank you. Do I get a second? Okay, we've got a motion and a second that the proposal is germane to the scope and purposes of the bar. Do we have any discussion? Okay. All right, we can publish the poll. We will close the poll in 5. Motion passes 82 to the same 3. Now we need a motion to support the recommendation, the committee to promote inclusion in the profession support of the Judicial Council budget request for fiscal year 2023 funding for civil legal services grants for victims of domestic violence. Do I have that motion? Got a motion, got a second? Any discussion? All right, we can publish the poll. All right, we're going to close it in 5 seconds. Motion carries 94 to 0. Oh, the 3.
Good stuff.
Thank you, Kyle. We appreciate it.
Thank you, Madam President. Thank you.
All right, now I'm going to call Mark Middleton up. He's one of our lobbyists to give a legislative update.
Thank you, Madam President. We are in the second year of a 2-year cycle. During the interim, your legislative team's been working with Kyle and the others on the ACL in regard to that process. We have a couple of carryover items as well. And then we've spent just some time just generally with the legislature. And that's what we'll be doing between now and the beginning of the session when it starts in January. I know a lot of people are interested in the special session that's coming up on November the 5th. Fortunately, that call is very narrow. It's limited to redistricting and some other local issues. If anybody has any questions about the special session or any of our carryover items, I'll be here after the meeting. And and also will say, as somebody who's represented you all for a long time, I would love to have votes with only 3 no votes. So I'm very happy. I would be very happy for that result when we get to January. So if there are any questions, I'll be glad to entertain them after the meeting.
Thanks, Mark. We appreciate that. Moving on to the president's report. I'm the president. I'm not gonna, we've been here and y'all done a great job. I appreciate everyone's attention. I do just want to give one brief announcement. Over the year and some change, I've served on the Judicial COVID Task Force. And one thing that we just want to let folks know, the task force is still up and running and going. But one thing that's important for us to know is if you are going to court and you have an issue or an experience that you feel like is challenging or concerning from a public health perspective, and you don't know what to do and you're seeing things in court that you don't want to see in that regard, please feel free to reach out to the members of the task force. You can reach out to me, you can reach out to Chief Justice Namias or Justice LaGrua, who's the chair of the task force. And we want to help. If there are issues, we want to help address them. And we know that informally addressing them is much better than other ways of addressing them. So I make myself available to the lawyers of the state of Georgia who want to contact me to tell me all sorts of things, but they can also tell me about that. We want to make sure that we just that we're safe and healthy in the things that we do. Well, we'll keep it in confidence, but we have to. Yes, we will keep it in confidence, but so please feel free to reach out. And with that, that is my report, and we will save talking for a different day. So next up, I'm going to call Tony Del Campo.
All right, good afternoon, folks. This report will be mercifully short. The financials are on page 152 of your board book and basically shows that we are in really good shape. We budgeted a profit of $214,000, and that was made up of $550 profit from the Bar Center and a budgeted loss of $336,000 for a budgeted profit of $214,000. That did not come to pass. We hit the mark on the Bar Center operations. We came in at a profit of $500,000, but we actually came in at a profit from the bar of $466,000, which means that we are a profit of $966,000. That's not because we don't know how to budget. It's because we had a pandemic year, which provided a lot of savings. And most of that came from our meetings, from some personnel issues, from travel savings. So we are in good shape. Hopefully the budget will better reflect next year what our actual numbers are. So that is my report, unless anybody has any questions.
Next up, we've got our executive director report.
Thank you, Elizabeth. I'll say good morning to Mr. Chief Justices, the members of the court that are here, the members of the Board of Governors and friends. I will actually submit my comments and remarks in writing to you all before the end of next week in the interest of time. And we have some important reports coming from the Georgia Legal Services Program and the Chief Justice's Commission on Professionalism. However, I am around and available for questions either in the chat right now or later on today. I will take any that may be pressing right now. Thank you.
We respect your time. Next up, we've got Alyssa Haynes from the Young Lawyers Division. And remember, guys, this is a joint meeting with the YLD and the bar.
Like Elizabeth said, in the interest of time, I will just say I'm Alyssa Haynes. I am your YLD president. That's essentially my report. I really appreciate everyone being here. The YLD is excited to have our first official joint meeting with the Board of Governors. Kicked off our meeting with a general session yesterday. We were grateful to have Justices LaGrua and Colvin with us. We also had some guest appearances from our past presidents. John Pinnell was there, Joe Dent, and of course, Damon Elmore. And it's great to see how many people stay involved after the YLD term and continue with the big bar. So again, thanks for being here, and I look forward to the bar year. Thanks for your support.
Next up, you'll see the Office of General Counsel report. That's actually just a written report. So Ms. Frederick will not be giving an oral report. Yay. Next, we've got Tamika Daniel, the Deputy Director, Georgia Legal Services Program. Invite her to come down and speak. And while she's walking down here, she's also one of our members of the Disciplinary Board. So that is a heavy lift and a big commitment, and we just appreciate all the effort that you take.
Good afternoon. I promise to be brief. I stand before you as the newly promoted Deputy Director of Georgia Legal Services, and I am here on behalf of Rick Ruffalo, our Executive Director. Thank you for the opportunity. Just want to tell you, October is Domestic Violence Awareness Month, and that is really a big deal for Georgia Legal Services. Over the past year, we have been fortunate enough to represent over 4,000 survivors of domestic violence. For those 4,000 plus, we have been able to secure over $2 million in financial support through child support, benefits, housing, and other financial support. Our lawyers have led and participated in coordinated community responses to develop some solutions to family violence in our communities. We've been working on systematic changes as well that we hope are going to help keep our clients safer. We're working to develop family justice centers and specialty domestic violence courts across rural Georgia. We've worked with the Council of Superior Court Judges to draft new dating violence forms in accordance with the statute. And we've worked with the Judicial Council to develop new statewide divorce forms that can be found on the judicial portal. We want to thank you so much for your continued support of domestic violence issues, and more importantly, Georgia Legal Services as a whole. Thank you.
Congratulations again on that newly appointed position. All right, next we have Carly Squeer, the Director of the Chief Justice's Commission on Professionalism.
Good morning. My name is Carly Squeer. I'm the Executive Director for the Chief Justice's Commission on Professionalism, and joining me is Janet Watts, who we're both fully vaccinated. So we have our mask off. Just a very brief update. First, I want to let you know, congratulations to our new chair, Chief Justice David Namias. I wanted to make the board aware of an upcoming CLE. You can advance this. And thank our planning team. It will be December 17th, 2021. This will be our first in-person CLE since the pandemic. I want to thank our planning team, Paula Frederick, Bill Gentry, Terica Ganzi, and Molly Gillis. We're going to be talking about, you may remember on your bar dues, you're asked to designate an attorney in case you're incapacitated. What does that really mean? And how do we make it work for the entire system? For you as attorneys, for our clients, the courts, opposing counsel. So we're going to have some discussion around that on December 17th. Chief Justice Namias will be our special invited guest. We're still working on details, but look for November. And with that, I'm going to turn it over to Janet.
I am the chairperson of the selection committee for the Chief Justice Benham Awards. And we are opening nominations. They're open now for the 22nd annual awards. So they have to, your nominations must be complete before November 30th, 2021, and they are being accepted by electronic only this year. There won't be any extensions, so please take a look and see if you know people who should be honored for their.
And when we start.
I'm sorry. Oh, okay. And the planning stages for the award ceremony is they're early, but we do know the date. It's March 19th, 2022. Take a look around you, and if you know folks that do community service, they don't toot their own horn, you know, and so we need for you to look and see who they are and nominate them within the next 6 weeks.
And when we started our activities in community service, we wanted the community to see lawyers as servants of the community. And we've encouraged lawyers to become involved with the Boy Scouts, the Girl Scouts, the civic clubs, the business leagues, and become part and partial of the community. And we are seeing this more and more. And lawyers have a better feeling about the practice of law, and the community has a better feeling about them. I have been rabid about community service because one of our first efforts was building a Habitat for Humanity house. The members of the Bar Association came together and worked on that. One last vignette I want to leave you with is that when we were building the Habitat for Humanity house, almost 20 years ago, everybody knew that I didn't have any carpentry skills. And as fate would have it, I was nailing the face on a window, and the occupant of that house was standing outside the window. I missed the nail. The hammer left my hand, and hit the woman in the head, knocking her out. They took my apron from me and everything else and says, you sit over there and you bring us refreshment. And I've been trying to prove myself worthy ever since that period of time. But the most difficult thing was I was waiting for the 2-year statute of limitations to run on the tort that I committed. So those of you who are involved in community service, just be careful in what you're doing and try to project an image of lawyers as community servants, because unfortunately, people see us more as adversaries than as servants. But when you reflect on tonight, this is what we're about. We're about building up our community.
So, thank you all for your time. After such serious discussions today about some of the small percentage of lawyers that make us look bad, the Community Service Awards is about all of the wonderful things that we do for not only the profession, but our communities. And so thank you for your time. Thank you, Janet, for serving as chair.
All right, now we move on to the written reports, which is the time I read them aloud to you all. I'm kidding. I commend to you the written reports provided in your board book for your study at the pool. And with that, do we have any old business? Do we have any new business? Anything for good of the order? Before we adjourn, I just want to say thank you for all the hard work today. It was not easy, and I appreciate the professionalism. I appreciate the passion, and I appreciate all the hard work. We are all volunteers. One second. And then, so I appreciate everybody. I hope everyone does have safe travels. I also want to give a special kudos and thank you to our bar staff. This is not fun for them to navigate this hybrid world. Jennifer, thank you. This was a heavy lift today. Thank you to Guy T and to Michelle and to everyone for all the work. Having the clickers, having the software, it's needed and necessary and new, but it's hard. And we know that. So for all of you who don't like change, I get it. But this makes this meeting possible. And so with that, I think that Javon Hicks has something that she would like to say before we adjourn.
I'm running. Just on the announcements, I want to, on behalf of the Attorney Wellness Committee, ask you to join the State Bar of Georgia team for the Out of Darkness Walk. It supports suicide awareness and prevention. You can get access to information on how to join our team or how to donate. The walk in Atlanta, Piedmont Park, is November 7th. Come join us, get a Attorney Wellness Lawyers Living Well t-shirt, and we will appreciate your support. Thanks.
All right, that with no further business and us having concluded what we have, this meeting is adjourned. Oh, return your clickers, please. To Geikie. Yeah, return the clickers to state bar staff members.